Constitutional Conversations is a series of discussions by America's leading scholars about the principles, framing, ratification, and implementation of constitutional government in the United States. This series is hosted by the James Madison Memorial Fellowship Foundation of Alexandria, Virginia.
The question of whether women were considered citizens under the U.S. Constitution is immensely complicated. The U.S. Constitution, by and large, is a gender-neutral document. Many of the provisions talk about persons rather than males or men. And so theoretically, a lot of the provisions, for example, with regard to the presidency or serving in Congress, could be open to women. The 3/5 clause, as it was written, comprehended all inhabitants of the United States, including women. And of course, it counted enslaved people as 3/5 of the total population. But women were considered inhabitants of the United States. But is that the same as citizens? The question of citizenship took a lot of time, a long time, to be decided in the United States because there were questions of state citizenship and federal citizenship. So what we know is that women had a lot of the rights of citizens. They couldn't vote or hold public office, and this is more by tradition than explicit exclusion. However, they did have a lot of the rights that are protected, say, under the Bill of Rights. So one of the most important rights that people at the time held as sacred was the right of petition, and women could petition their government for redress of grievances. Women had freedom of religion. To the extent that custom allowed women to speak publicly, they had freedom of speech. So women did have certain civil rights. They had the right to trial by jury, but not by a jury of their peers, because they were not tried by a jury of women. But the question of citizenship then developed over time, both in the states and at the federal level. And one significant development occurred in 1790 when Congress passed the first Naturalization Act. And it allowed naturalization for, and the specific clause was, free white males. Now, women who were married to these free white males would then be automatically naturalized. But that was one important distinction about citizenship that started to emerge. However, because the Constitution allowed each state to decide for itself whether who could vote in the state and what the qualifications were, you have the exception of women voting for the period from 1776 to 1807 in New Jersey. And then later on, after the Civil War, you had some states in the West, like Utah and Colorado and Wyoming, enfranchising women. Now, one important change occurred also after the Civil War with the 14th Amendment in 1868. And that was the first time that the federal government defined citizenship in terms of males. And in many cases, women who had been campaigning for enfranchisement for women were devastated by the 14th Amendment because this seemed to limit federal citizenship to men, to males. It expanded the franchise to black males, but in the process, it excluded women. And so that's why you needed the 20th Amendment in 1919 for women to get the vote throughout the United States. So the question of citizenship then evolved slowly over time and in a checkerboard fashion because of the different rights and responsibilities of the state government and the federal government, and as the federal government changed over time.
Constitutional Conversations is made possible by a generous grant from the Fairleigh S. Dickinson Jr. Foundation. Constitutional Conversations is made possible by the James Madison Education Fund.